Imagine the shockwaves that rippled through the sports world when Jon Gruden secured a monumental legal victory against the NFL in a Nevada Supreme Court ruling. This isn't just a win for Gruden. It's a landmark decision that could reshape how disputes between employees and employers are handled. But here's where it gets controversial. The court's decision has sparked a debate about the fairness of arbitration clauses in employment contracts. Let's dive into the details. The Nevada Supreme Court ruled on August 11th that Jon Gruden's lawsuit against the NFL cannot be forced into private arbitration. Gruden's lawsuit alleges that the NFL deliberately leaked disparaging emails he wrote, which included misogynistic and homophobic language. The court sided with Gruden, finding that an arbitration clause in the NFL's constitution is unconscionable. This clause would have allowed NFL Commissioner Roger Goodell to arbitrate disputes over his own conduct, effectively giving him the power to judge himself. We're very pleased with the Nevada Supreme Court's decision, not just for Coach Gruden, but for all employees facing an employer's unfair arbitration process, said Gruden's attorney Adam Hosmer-Henner. This victory further vindicates Coach Gruden's reputation, and it clears the way to swiftly bringing him full justice and holding the NFL accountable. The NFL has not yet responded to requests for comment, but the league's next move could be to appeal the decision to the U.S. Supreme Court. However, it remains unclear whether the NFL will take this step or if the U.S. Supreme Court would even agree to hear the case. This ruling comes nearly 4 years after Gruden's dramatic resignation as head coach of the Las Vegas Raiders. The emails in question were written during his time as an NFL analyst for ESPN between 2011 and 2018. They were published by multiple news outlets as part of an investigation into the then Washington football team. Gruden subsequently sued the NFL and Goodell in November 2021, alleging a malicious and orchestrated campaign to destroy his career. The NFL has consistently described these claims as baseless, asserting that Gruden is solely responsible for the contents of his emails. Most of the legal battle since then has centered not on the specifics of the case, but on where it should be resolved. Gruden has argued that his lawsuit should proceed in public view in a Nevada district court because he was not a team or league employee at the time of the dispute. The NFL, on the other hand, has sought to push the case into private arbitration, citing a broad arbitration clause in its constitution that all league employees must follow. A district judge in Nevada initially ruled in Gruden's favor, but the NFL successfully appealed the matter to a 3-judge panel of the state's Supreme Court. Monday's ruling, which reversed the previous decision, came after Gruden requested a rehearing before the full court. And this is the part most people miss. The court's decision highlights a broader issue, the potential for unfairness in arbitration clauses that favor employers. This ruling could set a precedent for future cases, potentially empowering employees to challenge similar clauses in their contracts. So, what do you think? Does this ruling set a fair precedent for future employment disputes, or does it open the door to more legal battles? Share your thoughts in the comments below. Let's discuss.